Well, in a crucial hearing today, following the revelations by several media reports on the Pegasus snooping issue, a Supreme Court bench of Chief Justice of India N.V. Ramana and Justice Suryakant today asked a bunch of 9 petitioners to serve their copies of the petitions on the central government, and the case will now be taken up next Tuesday, that is August 10th. However, today in this video, we will be dissecting what all happened in the hour-long courtroom hearing today before the Court of Chief Justice of India, N.V. Ramana. A brief background before we start. The bench was hearing a batch of petitions from a total 9 petitioners who had approached the court seeking an independent probe into the Pegasus revelations that has rocked the country since the last 1.5 months. The latest being that numbers of a Supreme Court of India registrars and even one former Supreme Court judge was found to be in the Pegasus snooping list. Well, the first petitioner in this case was Advocate M.L. Sharma. Known to be filing a lot of public interest litigations, Mr. Sharma briefed the court that Pegasus snooping needs a court-monitored investigation since it's completely unlawful. However, the bench of Chief Justice of India, N.V. Ramana and Justice Suryakant had serious reservations about entertaining M.L. Sharma's petition since he had made the Prime Minister of India, Narendra Modi, and Home Minister Amit Shah as parties in the petition. In fact, the bench noted that how can Supreme Court issue notice to these 2 people who he has named in his petition without hearing them? Apart from M.L. Sharma, today's hearing was started by senior advocate Kapil Sibal, appearing for N. Ram and Sashi Kumar, senior journalists who had moved Supreme Court seeking an independent probe into the Pegasus scandal. Senior advocate Sibal first and foremost impressed upon the court an order from a California court stating that NSO's spyware, which is known as the Pegasus spyware, is only sold to vetted sovereign governments and not to private agencies. The moot question that senior advocate Kapil Sibal put forth before the Supreme Court was, if at all the Supreme Court of India has purchased the Pegasus spyware, then the details about the software, its placement, where the hardware has been kept and how it has been used needs to be clarified before the Supreme Court of India. Senior advocate Sibal also stated that the reports in the media now make it immensely clear that Pegasus was indeed used by the central government. However, one of the key questions posed by the Chief Justice of India N.V. Ramana-led bench was, if persons' mobile phone was hacked or they came to know that their mobile phone was infected with the Pegasus spyware, then why did they not approach the local police station to file an FIR under the Information Technology Act? The bench even went on to ponder as to which sections would have been applicable, whether it's Section 66, Section 66A or Section 66E of the Information Technology Act. At this juncture, senior advocate Shyam Diwan, appearing for a couple of other petitioners, submitted before the Supreme Court that once you know who is the culprit in a case, it is only then you can approach the police for a complaint. In this case, one does not know who used the Pegasus spyware and how it was used, and that is why this entire case has come before the Supreme Court of India. He also stated that this is not about 2 or 3 people, but about hundreds of individuals. And today there are about 300 individuals, and tomorrow there could be thousands. And that a court-monitored probe is extremely urgent in this case. He even made a statement that such kind of snooping into the mobile phones of private individuals was like a war on the citizens by the government of India. However, the bench stuck to its moot question as to why was no local complaint registered when the persons came to know that their phones were tapped. Senior advocate Arvind Datar, in an attempt to answer this specific question as to why no FIR was lodged, submitted before the court that this case revolves around a Pegasus project. This project, which started in 2019, was carried on by a French agency in collaboration with other media organizations like The Wire from India and other international organizations like the Washington Post too. He stated that 2-year-long investigations were carried out, numbers were jotted down, and mobile phones were given for forensic examinations. After the forensic examinations confirmed that some mobile phones were indeed infected with the Pegasus spyware, did the probe move on? And it was only in July 2021 that everyone had definite names of the people whose mobile phones were indeed infected with the Pegasus spyware. And now the only question that remains to be answered by the central government is, why was Pegasus spyware used? Senior advocate Meenakshi Arora in this context also cited the submission made by the then Law Minister and IT Minister Ravi Shankar Prasad in November 2019 before the Indian Parliament, where it stated that the Pegasus spyware was not used unauthorizedly. Senior advocate Kapil Sibal at this juncture intervened and stated that if the central government knew that if at all Pegasus spyware was being used on the phones of Indian citizens, then why not an FIR was lodged, or why there was no probe conducted by the government of India? Essentially because this entire matter deal with privacy, rights, dignity of the Indian citizens. Senior advocate Rakesh Dwivedi, appearing for a group of petitioners whose numbers were also there on the Pegasus snooping list, submitted that this entire matter is not just a criminal matter but also a constitutional matter. He went on to submit that he can understand that the phones of terrorists, etc., being tapped in the area of Jammu and Kashmir or someplace else, which is riddled with problems. However, tapping on the phones of common citizens is not rightful or legal. He also said that the court should take cognizance of this entire matter to restore the trust and confidence of the Indian citizens at large that their phones and their conversations are secure. Since there were no counsels representing the central government in the Supreme Court today, the court has now asked all petitioners to serve an advance copy of their petitions upon the central government, and that the case will be next heard on August 10th. It is likely the central government will prima facie give a first response in court that day. Well, that was a wrap up of today's courtroom hearing in the Pegasus snooping scandal. We'll be back next week with more updates on this particular issue. Please stay tuned with barandbench.com for more updates and in-depth stories from the corridors of law and justice.